Chapter IX, Complaint, SS 140, Recitals of the Complaint, to successfully impeach a fraudulent conveyance. It ordinarily devolves upon the complainants to aver in the pleading that they were creditors at the time of the alienation in controversy, and to state against whom the judgment proceeded upon was recovered. The complaint will ordinarily be considered defective unless it appears upon its face that an indebtedness exists, and that the plaintiff has exhausted his remedy at law. And such averments cannot usually be supplied by an allegation of a total want of property, or the uselessness of an execution, and if it does not appear that the execution was issued to the county of the debtor's residence, or other proper county, the complaint is not aided by an averment that it was returned unsatisfied. According to some of the cases, it is not sufficient to entitle the creditor to the aid of a court of equity merely to show that the debtor made a fraudulent disposition of a portion of his property. The complainant must set forth that the alienation of property complained of embarrassed him in obtaining satisfaction of his debt. For if the debtor has other property subject to the judgment and execution sufficient to satisfy the debt, there is no necessity for the creditor to resort to equity. The bill should recite facts sufficient to indicate that the judgment cannot be collected without equitable aid. This averment is material, and a decree upon proofs without this necessary allegation is said to be erroneous, since the defendant cannot be required to meet and overcome evidence not responsive to the pleadings. It may be here observed concerning the rules of pleading that, generally speaking, it is the right of an antagonistic defendant to have all the material facts on which relief is sought specifically set forth in the bill, to the end that such facts may be admitted or controverted by the answer in testimony. And usually no proofs will be admitted unless secundum allegata. Hence, where it is the purpose of the complainants to seek relief for creditors other than themselves, such intention should be manifested by suitable averments in the bill. SS 141, Pleading Fraud. Fraud has been said in a general way to be a conclusion of law, though perhaps, more correctly speaking, it is the judgment of law upon facts and intents, a mere general averment that a deed was fraudulent, or that it was made with the intent to hinder, delay, or defraud creditors, has been regarded as an insufficient method of pleading. Peckham, J., has said, mere general allegations of fraud or conspiracy are of no value as stating a cause of action. There must, ordinarily, be averments of the facts which constitute the fraud, or which tend to support the conclusion. Relief will not be afforded upon the ground of fraud unless it be made a distinct allegation in the bill, so that it may be put in issue by the pleadings. In Flewell and v. Crane, the averments were that a conveyance, purporting on its face to be made in payment of a debt due from the grantor to the grantee, was fraudulent and void as against pre-existing creditors, and that it was made with the intent to hinder, delay, or defraud said creditors. There was no averment impeaching the adequacy or bona fides of the consideration expressed, nor asserting that the debt was not justly due from the grantor to the grantee. No setting up a secret trust for the grantor. The pleading was declared insufficient to support a final decree, rendered upon a decree pro confesso, which adjudged the conveyance void for fraud. The rule is that the facts upon which the fraud is predicated cannot be left to inference, but must be distinctly and specifically averred. If a bill is filed to set aside a deed upon the ground of undue influence, it is not necessary to allege every fact showing the actual exercise of undue influence, but the relations of the parties ought to be stated, and the general fact of undue influence alleged, and some specific instances given from which the court could infer it. The common law rule was clearly settled that fraud must be distinctly alleged and as distinctly proved, and that it was not allowable to leave fraud to be inferred wholly from the facts, while it may not be absolutely essential to employ the word fraud in the pleading. Yet the facts stated should show distinctly that fraud is charged. The New York Court of Appeals say that the use of the word fraud or fraudulent, in order to characterize the transaction, or specify the ground of relief, is not absolutely necessary, where the circumstances are such as do not warrant the court in avoiding the transaction in toto. It may be avoided as an absolute conveyance, and permitted to stand as a security. But such relief cannot be afforded unless the complaint contains allegations adapted thereto. An averment of an intent to defraud is one of fact, and not a statement of a conclusion of law. It must be alleged as well as proved, and it may be directly testified to as a fact. SS 142, Evidence not to be pleaded. General certainty is sufficient in pleading inequity, and though a mere general charge of fraud is insufficient, it is not to be understood that the particular facts and circumstances which confirm or establish it should be minutely charged. It is not necessary or proper that pleadings at law or in equity should be encumbered with all the matters of evidence the complainant may intend to introduce, a general averment of facts, not of conclusions of law upon which the rights of the parties depend, is sufficient. By the elementary rules of pleading, facts may be pleaded according to their legal effect, without setting forth the particulars that lead to it, and necessary circumstances implied by law need not be expressed in the plea. So much of the complaint, however, as sets out in detail the inceptive steps which culminated in the alleged fraudulent conveyance, is not a relevant or redundant matter. SS 143, alleging insolvency, as elsewhere shown. A voluntary conveyance is not generally regarded as fraudulent per se. If a debtor is perfectly solvent, he can do what he will with his property so long as he does not dispose of so much of it as to disable him from paying his debts. This is a rule of pleading as well as of evidence. Hence, a bill which contained no allegation that the debtor at the time of the alienation was insolvent or embarrassed was held bad, for it is only when an inadequate amount of property remains that creditors have the legal right to complain. The court said that, for aught that appeared in the pleading, the debtor might have been possessed of ample means, other than the property in controversy, to pay his debts, and in such a case the conveyance is not ordinarily open to the attack of creditors. A man is said to be insolvent when he is not in a condition to pay his debts in the ordinary course, as persons carrying on trade usually do, or when all his obligations could not be collected by legal process out of his own means. A complaint which states that the said WLJ, at the time of making said deed, did not have sufficient property remaining, subject to execution, to pay all his said debts, but by means of said conveyance rendered himself wholly insolvent, and has not now nor has, at any time since said conveyance, had sufficient property, subject to execution, out of which said debts could be made, is sufficient. SS 144. Allegations concerning consideration. As regards allegations of consideration, the bill will be upheld if it distinctly recites either of three things. First, that the conveyance was wholly without consideration. Second, that it was fraudulent and there was a consideration which, in cases of technical or constructive fraud, the complainant was willing to allow or has offered to return. Or third, that the complainant is not informed and has no means of ascertaining whether there was a consideration, and that these facts are peculiarly within the defendant's knowledge. In this latter case, the bill should pray for a discovery. SS 145. Fraudulent intent. It is usually of vital importance that the creditor should allege in the bill that the conveyance attacked was made with the intent to hinder, delay, or defraud creditors. The effective intent, as related to fraudulent alienations, is elsewhere made a special subject of discussion. We may here observe that an averment to the effect that the grantee, the debtor's wife, gave no consideration, and that the whole consideration came from the debtor, sufficiently shows bad faith or fraudulent intent on her part. SS 146. Pleading inequity. The plaintiff's title and claim to the assistance of a court of equity must always be exposed by the pleadings. But the style and character of pleading inequity has always been of a more liberal cast than is permitted in other courts, as mispleading in matter of form has never been held to prejudice a party, provided the whole case is just and right in matter of substance, and supported by proper evidence. As a creditor's bill is often brought for a discovery as well as for relief, the complainant is at liberty to avail himself of any objections to proceedings on the part of the defendant affecting his rights, even though not specified or charged in the bill. This rule results from the necessity of the case, as a creditor cannot be supposed to be thoroughly acquainted with the conduct of his debtor toward third persons, especially when, as is generally the case in fraudulent transactions, efforts have been made to conceal the circumstances from the public. SS 147. Seeking discovery. The complainant, especially if he is prosecuting in a representative capacity, as, for instance, an assignee in bankruptcy, in seeking to set aside a fraudulent conveyance of real and personal property, has the right, as ancillary to the principal relief, to have a discovery from the defendants, and he properly seeks it with a view to supply the deficiency in his own knowledge, and his ignorance of the particulars sought not only entitles him to the discovery, but excuses the want of more precise specification of the particular fraud alleged. SS 148. Excusing lashes. Concealment of fraud. It frequently becomes vitally important to excuse, by appropriate recitals in the bill, apparent lashes on the part of the creditor in commencing the suit. In Forbes v. Overby, which was a bill filed by an assignee, charging fraud and conspiracy, and praying for a discovery and disclosure, the defendants contended upon a motion to dissolve an injunction, that the bill was insufficient in form and substance and ought to be dismissed, first, because of complainant's lashes in bringing this suit, and second, because the bill failed to set forth specifically the impediments to an earlier prosecution of the claim. It was objected that the bill did not explain why the complainant had remained in ignorance of his rights, and that it failed to recite the methods employed by defendants to fraudulently keep the complainant in such ignorance, and that it did not disclose how and when the complainant first came to a knowledge of the matters alleged as the basis of the suit. The court observed that there had been a great variety of decisions upon the question as to what lapse of time was sufficient to bar cases of this character, and declared the general rule to be that each suit must be governed by its own peculiar circumstances. The case under consideration, being a bill for a discovery, was distinguished by the court, on that ground, from Badger v. Badger, and it was said that a court would not compel a complainant, who was manifestly ignorant of the particulars of a fraud, to set out in his bill the very particulars concerning which a disclosure was sought. Lord Erskine said, "No length of time can prevent the unkenneling of a fraud." In Alden v. Gregory, Lord Northington exclaims, "The next question is in effect whether delay will purge a fraud. Never while I sit here. Every delay arising from it adds to the injustice and multiplies the oppression." Mr. Justice Story stated the rule as follows: "It is certainly true that length of time is no bar to a trust clearly established, and in a case where fraud is imputed and proved, length of time ought not, upon principles of eternal justice, to be admitted to repel relief. On the contrary, it would seem that the length of time during which the fraud has been successfully concealed and practiced is rather an aggravation of the offense, and calls more loudly upon a court of equity to give ample and decisive relief. It must be remembered, however, first, that the trust must be clearly established; second, that the facts must have been fraudulently and successfully concealed by the trustee from the knowledge of the cestui que trust. Long acquiescence and lashes by parties out of possession are productive of much hardship and injustice to others, and cannot be excused but by showing some actual hindrance or impediment caused by the fraud or concealment of the parties in possession which will appeal to the conscience of the Chancellor. The party who makes such an appeal should set forth in his bill specifically what the impediments to an earlier prosecution of his claim were, how he came to be so long ignorant of his rights, and the means used by the respondent to fraudulently keep him in ignorance, and how and when he first came to a knowledge of the matters alleged in the bill. Otherwise the courts will not grope after the truth of facts involved in the mists and obscurity consequent upon a great lapse of time." SS 149. Explaining delay, discovery of fraud, in cases where it is sought to avoid the statute of limitations, or rather to come within the exception to it, the plaintiff has been held to stringent rules of pleading and evidence. Especially must there be distinct averments as to the time when the fraud, mistake, concealment, or misrepresentation was discovered, and what the discovery is, so that the court may clearly see whether, by ordinary diligence, the discovery might not have been before made. This is necessary to enable the defendant to meet the fraud and disprove the alleged time of its discovery. A general allegation of ignorance at one time, and of knowledge at another, is of no effect. If the plaintiff made any particular discovery, it should be stated when it was made, what it was, how it was made, and why it was not made sooner. Fraud that will arrest the running of the statute must be secret and concealed, and not patent or known. The party seeking to elude the statute by reason of fraud must aver, and show that he used due diligence to detect it, and if he had the means of discovery in his power he will be held to have known it. In Cole v. McGlathries it appeared that the plaintiff had provided the defendant with money to pay certain debts. The defendant falsely affirmed that he had paid them, and fraudulently kept possession of the money. It was decided that the plaintiff was not entitled to recover for the reason that he had at all times the means of discovering the truth of the statements by making inquiries of the parties who should have received the money. This principle is further illustrated in the analogous case of McCown v. Whitmore, in which it appeared that the plaintiff had handed the defendant money to be deposited for the plaintiff in bank. The defendant told the plaintiff that he had made the deposit. It was held that even though the statement was false and made with a fraudulent design, the plaintiff could not recover because he might at all times have inquired at the bank and learned the truth. In Boyd v. Boyd, it was ruled that the concealment which would avoid the statute must go beyond mere silence. It must be something done to prevent discovery. The concealment must be the result of positive acts. An allegation that the defendants pretended and professed to the world that the transactions were bona fide was looked upon as being too general. In Wood v. Carpenter, a pleading which read as follows, and the plaintiff further avers that he had no knowledge of the facts so concealed by the defendant until the year ad. 1872, and a few weeks only before the bringing of this suit, was held to be clearly bad. The court in this case, in a critical and exhaustive opinion, review many of the cases which have just been considered, and then observe that a wide and careful survey of the authorities leads to the following conclusions. First, the fraud and deceit which enabled the offender to do the wrong may precede its perpetration. The length of time is not material, provided there is the relation of design and its consummation. Second, concealment by mere silence is not enough. There must be some trick or contrivance intended to exclude suspicion and prevent inquiry. Third, there must be reasonable diligence, and the means of knowledge are the same thing in effect as knowledge itself. Fourth, the circumstances of the discovery must be fully stated and proved, and the delay which has occurred must be shown to be consistent with the requisite diligence. SS 150. Complaints bad for multifariousness. Judge Story says that multifariousness is the improperly joining in one bill distinct and independent matters, and thereby confounding them, as, for example, the uniting in one bill of several matters, perfectly distinct and unconnected, against one defendant, or the demand of several matters of a distinct and independent nature against several defendants in the same bill. What is more familiarly understood by multifariousness as applied to a bill is where a party is brought as a defendant upon a record, with a large portion of which, and of the case made by which, he has no connection whatsoever. In United States v. Bell Telephone Company, Mr. Justice Miller used these words: "The principle of multifariousness is one very largely of convenience, and is more often applied where two parties are attempted to be brought together by a bill in chancery who have no common interest in the litigation, whereby one party is compelled to join in the expense and trouble of a suit in which he and his co-defendant have no common interest, or in which one party is joined as complainant with another party with whom in like manner he either has no interest at all, or no such interest as requires the defendant to litigate it in the same action. The authorities bearing upon this question are very numerous, but there is deducible from them all no positive and flexible rule as to what, in the sense of courts of equity, constitutes multifariousness, which is fatal on demur. Indeed, it seems to be generally recognized as an impossibility to formulate a general rule as to what is considered multifariousness. Every case must be governed by its own circumstances, and the court must exercise a sound discretion on the subject. The rule in relation to multifariousness, say the Supreme Court in Iowa, is one of convenience. And though the matters set forth in the pleading are distinct, yet if justice can be administered between the parties without a multiplicity of suits, the objection will not prevail. The objection that the bill is multifarious is always discouraged by the courts when, instead of advancing, it will defeat the ends of justice. SS 151. Pleadings held not multifarious, such being the general condition of the authorities as to multifarious pleadings. It follows that the practitioner must rely upon instances and illustrations drawn from reported cases for his guidance. In a suit before the Supreme Judicial Court of New Hampshire, it was decided that it was not multifarious to join in a creditor's bill as parties defendant with the debtor, several persons to whom he conveyed distinct parcels of property, out of which the creditor sought satisfaction of his debt, although such persons might have no common interest in the several parcels conveyed. And in Dimmick v. Bixby, it was held that a demurrer for multifariousness would hold good only when the plaintiff claimed several matters of a different nature, and not when one general right was asserted, although the defendants might have separate and distinct rights. The same principle is recognized in Boyd v. Hoyt. That was a case of a creditor's bill brought to reach property of a judgment debtor which had been fraudulently transferred to two or more persons holding different portions of it by distinct conveyance, and it was decided that such persons might be joined. The Chancellor lays it down that when the object of a suit is single, but different persons have or claim separate interests in distinct or independent matters, all connected with and arising out of the single object of the suit, the complainant may bring such persons before the court as defendants, so that the whole object of the bill may be effected in one suit, and further unnecessary and useless litigation prevented. The case of Morton v. Weil is an important illustration in point. Creditors by different judgments united in bringing a suit against the executors under the will of a decedent, alleging the fraud of that person in contracting the debts, and joined as defendants various parties having liens upon, or title to, the property in question by reason of judgments or assignments, alleging that such liens or titles were fraudulently obtained, and praying that the same might be vacated, and the defendants compelled to account for and pay over the property. On demurrer to the bill, it was decided that the parties to it were properly joined, and that in other respects it was sufficient. In another case, a creditor's bill filed against the debtor and his grantees for the purpose of setting aside a number of voluntary conveyances, severally made to each of the parties, was held to be good, and in Harrison v. Hallam, the court say that it is proper, where there are several judgment debtors in the same judgment, and one of them has made a fraudulent conveyance to one grantee, and another has made a similar conveyance to another grantee, and a third has made a like conveyance to still another grantee, to unite all the debtors and their several fraudulent grantees in one common bill for the relief of the judgment. Creditors, again, were a debtor, with intent to defraud his creditors, purchase land, causing the deed to be made to his wife, who participated in the fraud and conveyed the land to another person with the same intent, who in turn conveyed it to a third, both grantees being cognizant of the fraud. It was held, in an action brought by a creditor to set aside the conveyances, that both transactions being of the same nature, though different in form, could be properly joined in the same complaint. A bill is not regarded as multifarious, though brought to recover different portions of the estate of a debtor from several defendants. SS 152. The cases upon this subject are almost without number. In DeWolf v. Sprague MFG Co., it appeared that the plaintiff held a judgment lien upon certain real estate upon which a trust mortgage had been executed, which, if valid, was entitled to priority. The suit was brought to set aside or postpone the mortgage, on the ground that it was void against the complaining creditor, and for a foreclosure of the judgment lien, and for possession, and the mortgagors and the trust mortgagee were made defendants. The court, after protracted argument and an extended review of the authorities, held that the bill was not multifarious. In Parker v. Flagg, the court say, the bill is brought by the executor, representing all the creditors of an insolvent estate, to set aside conveyances made by the testator of all his property, real and personal, in fraud of those creditors, to his wife, who is the sole defendant. Some of the property consists of mortgages, to recover which the plaintiff has no adequate remedy at law. All the conveyances appear to have been part of one scheme, and no objection is, nor, it would seem, could be taken to the bill for multifariousness. The demurrer was erroneously sustained, and should have been overruled. It is perhaps unnecessary to further multiply illustrations. Some of the cases have certainly gone to an extreme limit, and parties have been held together as defendants in one action by a very slender thread of reasoning. The St. Louis Court of Appeals, commenting upon the subject, say, the principle that it is not sufficient that the defendants are all concerned in some general charge, such as fraud on the part of the debtor, or that as grantees of distinct properties by distinct conveyances they obtain title through him, but that all the defendants should at least have an interest in the principal point in issue in the case, is surely of some value as a general test. In cases like the present, it would be decisive. Here there is no material issue in which all the defendants have a common interest, and consequently no tie to make them defendants in one suit. It is obvious that, merely from convenience to plaintiffs, the defendants ought not to be put to the trouble and expense of litigating matters with which they are unconnected. These observations were made in a case in which there were 20 defendants having a common source of title from an alleged fraudulent grantor. The conveyances were separate and made at different times, and the defendants were beneficiaries and trustees indiscriminately joined. The bill was pronounced multifarious. The decision, however, can scarcely be harmonized with some of the authorities already discussed. SS 153. Alternative relief. In Alabama, it was held that a creditor's bill may be filed for a double purpose, asking in the alternative to have 2 or more conveyances canceled as intended to hinder, delay, and defraud creditors, or to have them construed as together constituting a general assignment inuring, under the statute of that state, to the benefit of all the insolvent's creditors equally. But in a later case in that state, the court feel constrained to depart from and overrule the decision upon this point. SS 154. Attacking different conveyances. The fact that a plaintiff seeks to set aside 2 or more conveyances as fraudulent does not require that each conveyance shall be set forth in a separate paragraph as the basis of a separate cause of action. They constitute but one cause of action: the fraudulent disposition of his property by the judgment debtor. SS 155. Prayer of complaint. Variance, verification. As a general rule in the modern procedure, a mistake in the demand for relief is not fatal. In Buswell v. Links, the court said, the point is made that the bill was framed upon the basis of a claim that there had been a fraudulent trust deed, and a receiver had been prayed for, while the relief given in setting aside the fraudulent conveyance and adjudging a sale of the leasehold under execution was inconsistent with the prayer of the complaint. The sufficient answer to this proposition is that the judgment was such as the court was bound to give upon the allegations and proofs without reference to the relief demanded, and where the bill, in addition to the general demand for relief, contained a prayer that a deed be set aside, it was held that, merely because of a prayer that the defendant be decreed to give the complainant possession of the land, the bill would not be treated as a bill for possession, nor dismissed on the ground that ejectment was the proper remedy. As a general rule, complainants are entitled, under a prayer for general relief, to any judgment consistent with the case made in their bill, but they are not usually entitled to a decree covering and including matters not referred to in the pleadings, and as to which the respondents have never had their day in court. The court will not hesitate to dismiss a bill which presents a case totally different from the testimony in the record, and no decree can ordinarily be made on grounds not stated in the bill. The rule is explicit and absolute, that a party must recover in chancery according to the case made by his bill or not at all. Secundum allegata as well as probata, matters not charged in the bill should not be considered on the hearing. If, however, the special prayers are inapt and incongruous, and so framed that no relief can be granted under them, the court under the prayer for general relief may render any appropriate judgment consistent with the case made by the bill. Courts of equity give judgment for money only where that is all the relief needed. The objection that a bill is not verified is immaterial, as a bill in equity need not usually be sworn to unless it is sought to use it as evidence upon an application for a provisional injunction or other similar relief. SS 156. Amendment. A variance between the actual date of the judgment and that set forth in a creditor's bill based on it may be corrected by amendment at any time during the proceedings, but as the complainant is not absolutely confined to the exact date stated in the bill, the amendment may be unnecessary. An amendment of a bill as to the description of the property under well-established rules of procedure only operates from the time of the service of the amended pleading. The bill may be amended on the final hearing in the United States Circuit Court, so as to state that the value of the matter in dispute exceeds $500. Speaking upon the subject of amendments, Davis, J., said, in Neal v. Niels, to accomplish the object for which a court of equity was created, it has the power to adapt its proceedings to the exigency of each particular case. But this power would very often be ineffectual for the purpose, unless it also possessed the additional power, after a cause was heard in a case for relief made out, but not the case disclosed by the bill, to allow an alteration of the pleadings on terms that the party not in fault would have no reasonable ground to object to. That the court has this power and can, upon hearing the cause, if unable to do complete justice by reason of defective pleadings, permit amendments, both of bills and answers, is sustained by the authorities. The granting of amendments of pleadings in chancery rests in the sound discretion of the court. SS 157. Description. Aside from interests not liable to execution, the fact that a creditor is compelled to file a bill in equity usually implies ignorance on his part of the exact character and form in which the debtor has invested or secreted his property. If such were not the case, process of execution would be invoked. It should not, therefore, be necessary to particularly describe or indicate in the complaint the assets, whether legal or equitable, which it is proposed to reach by the bill. Thus a bill was entertained which alleged that the defendant has equitable interests, things in action, and other property which cannot be reached by execution, and that he has also debts due to him from persons unknown. In Miller v. Sherry, the original bill was in the form of a creditor's bill. It contained nothing specific except as to certain transactions between the debtor and one Richardson. There was no other part of the bill upon which issue could be taken as to any particular property. The court held that it was effectual for the purpose of creating a general lien upon the assets of the debtor, as a means of discovery, and as the foundation for an injunction and in order that the debtor execute a conveyance to a receiver. Furthermore, that if it became necessary to litigate as to any specific claim, other than that against Richardson already specified, an amendment to the bill would have been indispensable. The bill did not create a lis pendens operating as notice affecting any real estate. To have that effect, the recital in the description must be so definite that anyone reading it can thereby learn what property is intended to be made the subject of the litigation. Where the complainant in a creditor's bill seeks to obtain satisfaction out of lands inherited or devised, and is unable to specify the lands, he may state that fact in the bill, and call upon the heirs to discover the lands devised or inherited, so that they may be reached by amendment of the bill or otherwise. If the description be indefinite, it may be aided by the evidence. The rule that an alienation of property made during the pendency of an action is subject to the final decree is, as shown by Mr. Bishop, of very ancient origin. Murray v. Ballou is the leading case in this country. The doctrine is important both as regards the titles of purchasers and the question of preferences among judgment creditors. In Scouten v. Bender, where an assignment was overturned, it was decided that the creditors were entitled to satisfaction of their judgments, respectively, out of the funds derived from the real estate in the order of priority of the judgments, and out of the personal fund in the order in which the bills were filed and the equitable liens created. The doctrine of lis pendens, it may be further remarked, is said to have no application to corporate stock or negotiable securities. Mr. Justice Bradley said in County of Warren v. Marcy, whilst the doctrine of constructive notice arising from lis pendens, though often severe in its application, is, on the whole, a wholesome and necessary one, and founded on principles affecting the authoritative administration of justice, the exception to its application is demanded by other considerations equally important, as affecting the free operations of commerce, and that confidence in the instruments by which it is carried on, which is so necessary in a business community. An attempt to discuss the various phases of the law of lis pendens is not possible in this connection. The exceptions that have crept into the rule that a party who meddles with property in controversy does so at his peril have frequently brought the proceedings of diligent creditors to naught. SS 157A. Change of venue. Territorial jurisdiction. In New York State, a motion to change the place of trial of an action, brought to annul a fraudulent conveyance, to the county in which certain real estate passing under the assignment is situated, cannot be defeated by an offer on the part of the plaintiff to stipulate that he will not attempt to reach such real estate. When a court of equity attempts to act directly upon real or personal property by its decree, the property must be within the territorial jurisdiction of the court. It is equally well settled that where one is the owner of land or other property in a foreign jurisdiction, which in equity and good conscience he ought to convey to another, the latter may sue him in equity in any jurisdiction in which he may be found, and compel him to convey the property.